Ready, start. Savage board by way of separate recovery applications which came to be allowed by the Labour Court and affirmed by the learned single judge, considering the fact that there was no right acquired in favor of the workman. After referring to the various decisions, ultimately the division bench of this court has allowed the appeals and quashed and set aside the order passed by the learned single judge as well as the award passed by the Labour Court. In the case of Hitendra Lakshmichand Soni, Supra, the factual matrix is that the workman has directly filed the recovery application under section 33C clause 2 of the ID Act for various claims which includes special allowance, salary for overtime, salary for weekly hours, bonus for 5 years, leave salary, gratuity, and retrenchment compensation. Considering the fact that the various claims were made after almost delay of 17 years and there was no right accrued in favor of the workmen, the order passed by the Labour Court came to be quashed and set aside. Further, there was substantive dispute as to the cause on account of which and the mode by which the service of the applicant's father came to an end, that is, on account of resignation or by way of retrenchment, and also about legality of alleged termination. Under these circumstances, it was held that the disputed questions cannot be adjudicated and decided by the court under section 33C clause 2 of the ID Act. In the case of Sahu Minerals and Properties Limited, Supra, three judges bench, the factual matrix before the apex court has that by two notifications the government of Bihar sent to the Labour Court, Chota Nagpur Division, Ranchi, applications in respect of 73 workers of the appellant for decision under section 33C clause 2 of the Industrial Disputes Act for retrenchment compensation. The argument on behalf of the appellant was that where there was a dispute before the Labour Court considering an application under section 33C2 as to whether the workman had been retrenched or the factory had been closed for reasons beyond the control of the employer. It was not a matter which the Labour Court was competent to decide, and that it was a matter which only an industrial tribunal considering a reference under section 10 is competent to decide. In the aforesaid decision, the apex court has observed in para 4 as under in Central Bank of India Limited versus P.S. Rajagopalan 1964 3 SCR 140, this court considered the scope of